Good afternoon, everyone. My name is Dina Blickstein. I'm a partner at the law firm of Haynes & Boone, specializing in post-grant proceedings, patent prosecution, and artificial intelligence. Joining me today are Jeremy Albright, Eliar Barazesh, and Roshan Mansingani. Jeremy, Eliar, and Roshan, can you introduce yourselves?
Sure, and thanks, Dina. My name's Jeremy Albright. I'm a senior associate at Norton Rose Fulbright. And like Dina, my practice is split between transactional work, mostly patent prosecution there. And also the other half of my practice is more disputes related and focuses on post-grant review trials, which we'll be talking about today.
And let's go to Eliar.
All right, thank you, Dina. My name is Eliar Barazesh. I'm a senior associate at the law firm Baker Botts in Austin, Texas. And like Dina and Jeremy, my practice is also a little bit of a mix. I focus on post-grant proceedings, also patent litigation, and then I also handle patent counseling, patent prosecution matters as well.
And Roshan.
Hi, I'm Roshan Mansinghani. I serve as the Assistant General Counsel of Unified Patents, which is a membership organization dedicated to improving patent quality, in part through some of the invalidity challenges we'll be talking about today. And prior to that, I spent a decade also at Baker Botts doing exactly what Eliar said, a lot of patent counseling, litigation, and patent prosecution matters.
Yeah. Well, welcome, and it's nice to have all three of you on the panel. Before we get started, let's say thank you to our sponsors. So first we have Mood, we have an online dispensary, followed by Sunburst Digital, a maker of #1 typing software for education, and Max Asset that helps conduct asset sales. And one more housekeeping item is our standard disclaimer that this material is for informational purposes only. It's not intended to be a legal advice of any kind. And should you need advice, you should consult an attorney or another appropriate professional. And with that, let's get started. Jeremy, let's start with you. What are post-grant review trials?
Sure. So at a high level, post-grant review trials are administrative trials to decide whether the claims of an issued patent are invalid. These trials are conducted by the Patent Trial and Appeal Board. We will probably refer to them as the PTAB, and that's a tribunal within the United States Patent and Trademark Office. And each post-grant review trial will typically be decided by a 3-member panel of administrative patent judges from the PTAB. There are 2 main types of post-grant review trials: inter partes reviews, or IPRs, and post-grant reviews, or PGRs, which, unfortunately are a little confusingly named because a post-grant review is a type of post-grant review trial. It's actually a specific type, separate from IPRs. These differ in filing timelines and the grounds on which a patent can be challenged. But, no matter the type, post-grant review trials typically proceed in the same way. A petition is filed. The patent owner gets a chance to explain why the petition shouldn't be instituted. The board decides whether to institute, and if they do, there'll be a series of briefs. Patent owner files a response, petitioner files a reply, and patent owner gets a surreply, as well as some limited discovery that is conducted in the process of preparing those briefs. There'll be an oral hearing, and then ultimately the PTAB will issue a final written decision determining whether or not the challenge claims are invalid.
Now, Eliar, if I'm a patent owner, I would think my only remedy is in district courts. Are these new proceedings in front of PTAB, or is that something that existed before?
Thanks, Dina. So these proceedings have been around since the 2013 time period. So they came into effect after passage and signing into law of the American Invents Act. But post-grant review trials are only applicable when to patents that have at least one claim with an effective filing date on or after March 16, 2013. So essentially AIA patents, first inventor to file. So to kind of answer your question, they've been around for a while, But before that 2013 period, they weren't in effect. So you had to go through other routes of challenging patent validity, such as ex parte reexamination or inter parte reexamination.
Now, why would somebody use this post-grant review trial remedy at the U.S. Patent Office instead of going to district courts? Roshan?
There are a few reasons why a person who is seeking to invalidate a patent would choose the Patent Office as a venue to litigate this issue. First is that it is the Patent Office. It's the same office that issued the patent. And so you have a set of people referred to as judges, but they're not the judges you would think about in district court. That's just the title. They are Patent Office employees, but they are experts at patents. And as a result, you get a more expert view typically of the issues related to the validity of the patent from the Patent Office than you would in front of a district court judge who may or may not have a technical background, as well as in front of a jury. So the expert review is one reason why. Another reason why is a dedicated time frame. So these trials have timeframes that are defined by statute. They're a little over 18 months to get a final decision on the challenge typically. Whereas in district court, if you were trying to litigate the same issue, you would, there's an uncertain time frame because judges can change schedules. There's not a very clear process by which that happens. And then finally, the process is streamlined, meaning that in a district court litigation, you are facing a lot of different issues. Patent validity is just one of them. Whereas in front of the Patent Trial and Appeal Board, the only issue in question is validity, and you do get certain types of discovery and depositions and other things that I'm sure we'll talk about later in the webinar, but it's all streamlined and focused on the issue of whether the patent is invalid or not. So those are three of the main reasons why people choose to seek invalidation of patents before the Patent Office using these proceedings.
Okay, now just to follow up on that, Roshan, do I have to select one venue or the other, or can these proceedings run in parallel?
These proceedings can run in parallel. There is some limitation on that. Specifically, if you choose to go before the Patent Office on one of the trial proceedings we're talking about today, and it reaches that final decision, as I mentioned, approximately 18 months or so after you file, then there is a form of estoppel, which does not allow you in the district court proceeding to raise certain invalidity challenges that you could have raised in front of the Patent Office. So you do have to make a choice towards the end of the proceeding, but you are able to pursue certain challenges to the validity of patent in the district court, while you also can pursue those other types of invalidity challenges in front of the Patent Office.
Okay, so let's explore this point a little further. Jeremy, I mean, can you just further describe what are the advantages of going with the post-grant review trial?
Sure, Dina. And so I think a primary advantage for a petitioner of doing a post-grant review trial is there's a better chance of the target patent's claims being invalidated. For one, the burden of proof in a post-grant review trial is lower than it would be in district court. So in a post-grant review, it's going to be a preponderance of the evidence to show that a claim is invalid. Whereas in the district court, it's going to be clear and convincing evidence. As Roshan mentioned, post-grant review trials are going to be decided by patent-savvy ALJs rather than a jury, which I think helps. I mean, just looking at the data, chances of a post-grant review trial from some recent PTO statistics being instituted, that's around 70%. So 70% of petitions, give or more or less, are instituted. And amongst those petitions that are instituted where a trial actually takes place, only around 5% uphold all of the challenge claims. And so I think it's a really strong avenue for pursuing patent invalidity. Also, post-grant review trials, they can encourage settlement. Around 40% of instituted trials, based on that same data I mentioned, settle before final written decision. And another benefit is they can save costs by potentially resulting in a stay of any co-pending district court litigation, especially if you file them early enough and you get the institution decision at an early stage in the district court litigation. There's a chance that you can stay that district court litigation and potentially stave off or avoid, if you're successful, the cost associated with, for example, discovery. And finally, as Rashawn mentioned, post-grant review trials are fast and they're on a schedule, about 18 months more. I mean, usually a little more, but around 18 months from filing the petition to the final written decision. And I looked up statistics for a popular district court for patent litigation is the Western District of Texas. They're known as being pretty fast. And from the data I saw, it can even take that district up to 24 months to reach a trial. So if you get your petition filed early, you could potentially resolve the case before you even went to trial, even in a speedy district court.
Jeremy, what about, let's, do you have any data points for comparison? You know, we all know that, you know, Texas courts are fairly fast, especially the Western District. What about other district courts across the country? What time frame are we looking at if we were to litigate a patent?
So I would actually toss that question over to someone with more district court litigation experience. But when the data, I was looking at data to try to find fast district courts, and 24 months to trial was very fast. The other district courts tended to be slower. I think there might have been one on the East Coast that was a little bit faster, but none of them that I saw beat the 18-month IPR timeline. And
That's right. Yeah, I can jump in on that, Jeremy. So the most popular district courts where patents are litigated are the District of Delaware, Northern District of California, the Eastern District of Texas, and the Western District of Texas. And then the Eastern District of Virginia is also known for a fast time frame. So those are courts that have specialized patent docketing rules. And to Jeremy's point, they are all within, you know, the fastest are going to be around that 24-month time frame, but they can go as long as 4 to 5 years, depending on the complexity of the case and things going on. So if you take the averages all in, the data I've seen kind of pegs it between 3 and 4 years as like the average time. If you take the most popular patent venues, which are the ones I mentioned, and they probably have at least 80 to 90% of the nation's patent docket amongst those 5 or so courts I mentioned.
Okay. So, you know, let's go back to the advantages and disadvantages. I mean, I think there's a lot of advantages with going with a post-grant review trial. Are there any disadvantages, Ilya?
Yeah, so there are a few. I mentioned it earlier, but just the applicability of the patents that could be subject to PGR has to have at least one claim with an effective filing date on or after March 16, 2013. We have estoppel listed. So one of the benefits with PGRs is that you can raise all sorts of unpatentability grounds. So you can raise prior art grounds under Section 102 and 103. Within those grounds, the type of prior art that you can raise isn't limited to publications. You can show like product prior art, like evidence of prior use, which is a big benefit. It expands the type of prior art relative to inter partes review proceedings. And you can also raise Section 112 and Section 101 grounds of unpatentability. So 112 written description and clarity of the claims, and also 101, obviously the statutory validity and whether a claim is valid on that basis. So with that benefit, though, you have the estoppel of you know, if the final written decision issues and you're raising those type of grounds, then you can be stopped on all those various invalidity grounds in district court if you lose. So you know, that's a pretty major drawback, and could explain why in some instances PGRs aren't as popular as inter partes review. The other aspects, we have patent owner's opportunity to amend claims. That's present in post-grant proceedings. That can be a disadvantage, as you bring your case and then within the proceeding, the patent owner kind of changes the scope of the claims by getting motions to amend to be approved by the patent office or by the PTAB. So that's, obviously a large disadvantage. And then in terms of the limited opportunity to develop the record and present true testimony, obviously, as we've discussed before, this is a streamlined proceeding. So, you're going to get the ability to have, expert depositions from folks who've submitted declarations. You have a little bit more, there is an opportunity, I think, versus IPRs to expand the record a little more compared to that other post-grant proceeding. But still, compared to district court litigation, it's much more streamlined, it's much more focused. So, there are going to be some disadvantages to patent owners and petitioners because of that. Some of the other, another major disadvantage I see is that the PGRs have to be filed within 9 months of a patent's issuance. So that temporal limitation can be kind of a burden. If you don't have a huge amount of time after the patent issues to file your PGR. So that can also be a drawback.
So it sounds like the post-grant review trials are preferable to district court litigation. Am I correct?
I think each situation can be different. I mean, I'm going to give the it depends answer, but I think that there are a lot of benefits, and just as both Jeremy and Roshan have mentioned, just the ability to have a fact finder who is an expert. PTAB judges, all they do is look at patents. Many, I think the majority of them, if not all of them, have a deep technical background. They've worked as patent attorneys generally before joining the PTAB. So your case is going to be in front of someone with a lot of really good experience. So compared to what could happen in some district courts, having to kind of, handhold a judge a little bit, and then obviously having the determination in front of a jury, your fact finder is going to be an expert. And that is a big benefit I see.
Okay. So this brings me to my next question. Especially if I'm the patent owner and someone brings this proceeding in front of the Patent Trials and Appeal Board, I'm going to wonder, am I going to lose my patent, Jeremy?
So when I was mentioning some statistics earlier about institution rates and how they're high and how it's very rare for all claims to survive if a trial is instituted, I could have painted a little bit of a grim picture, but the answer is no. I think, at least to me, it's remarkable that around 30% of petitions for post-grant review trials are denied. So when you're a patent owner, and I guess as part of that, I'd like to mention that for a petition to be successful, it's more than just its substance, right? And the patentability, the substantive patentability of the claims, because there are a litany of reasons that the board can decline to institute an otherwise meritorious position. And I think that makes a lot of that 30% denial rate. And I think we're going to get into some of those reasons later. But if you're a patent owner, you're definitely going to want to assess not just the substantive strength of the petition and consider whether you want to attack that in your preliminary response to the petition, but also assess whether there are any discretionary reasons, and you can get very creative here, that the board should not take up the petition, and make those arguments in your POPR to be one of those 30% of petitions that get denied. And so, that patent owner would lose their patent. But even if the trial gets instituted, you could still potentially win, right? You could win on the merits, even though I think in most cases, as I said earlier, at least one of the claims is going to be invalidated. So some of the claims which would survive, you'd still have your patent. And for district court litigation, actually you only need one infringed claim. So that might not even be a bad outcome for your given litigation campaign. But beyond that, there are options for sort of sidestepping the petition as it is by amending your claims. As Eliar mentioned earlier, there's an opportunity for you to amend your patent as part of a motion to amend mean, as a practical matter, I don't think many of those are successful, but there's another route to achieve a similar outcome of amending your claims, and that's by filing a request for ex parte reexamination that might actually get stayed until final written decision, but then it's going to run after that. And we've actually used that strategy successfully as a patent owner to effectively make it out of a post-grant review trial with some of our claims intact after concluding a subsequent ex parte reexamination.
So that sounds like one way to amend claims, but wouldn't that affect damages if there's a district court litigation?
It would, that's right. But I mean, the patent, you'll still have the patent, potentially.
Okay. So Roshan, I think we covered how long these trials take, but can you give us a recap of what happens in different phases?
Yeah, absolutely. So these types of trials before the patent office happen in two phases. This slide is actually fairly helpful. So it first starts off with the person who wants to challenge the patent, typically someone that's been accused of infringement of the patent in district court litigation, filing what's called a petition in the patent office. So not in district court, but in the patent office. Once that is filed, the patent office goes through some preliminary checks of the petition to make sure it meets certain basic requirements, really ministerial requirements, not substantive ones. And then a notice of filing date is accorded to the petition, excuse me. And that typically happens in weeks' time, not months. So between 3 and 6 weeks, sometimes sooner, sometimes a little longer. And that kicks off, once that filing date has been accorded, that kicks off the rest of the timelines that you see here. So from that moment, the patent owner has an option to file what's called a preliminary response. So this is a page limited, just like the petition is page limited or word count limited, response to the petition for the judges to consider. It's called preliminary because it is before the judges have made an initial decision on the process. And I think we have some details about that later on. So anyway, they have 3 months, up to 3 months. They can file sooner. And from the date that the patent owner files its preliminary response, if it chooses to do so, then there is a time limit of 3 months from when the petition is decided by the judges on a very generous standard, which is there a likelihood, effectively, that the petition has shown that at least one challenge claim is invalid? And if they basically think it's a meritorious case, they will institute the trial. And so it's called an institution decision. And the statistics that Jeremy was alluding to earlier of whether the 30+% of times that the board decides not to institute happens at this plus or minus 6 month time frame. So from the date of filing, a little over 6 months is the typical time frame from which an institution decision is made. And once that decision is made, for example, to institute, then the formal trial process begins. And the timeline is very useful to show what that trial process looks like. So the institution decision will be a decision that actually goes through and on a preliminary basis gives the reasons, the judge's reasons why they thought that the petition was meritorious in the case that they instituted. And at that point, the patent owner now has the opportunity to file what effectively is a mandatory written response, which is called the patent owner response. So no longer with that preliminary moniker. And they have 3 months to do that. The petitioner then gets to file a reply, and they have 3 months to do that. And then the patent owner gets to file a surreply. After that, in the typical case, the briefing is done. And then there's an opportunity, if the parties would like it, to have an oral hearing before the board, which usually lasts between 1 to 2 hours. And in that time frame, the judges get to ask the counsel for both sides questions, and they get to make oral presentations that are all based on the papers that were filed. And then the judges have a final written decision to issue. So the time frame for the final written decision to issue is 12 months from the institution date. So that's a statutory timeframe. It can be extended up to 6 months in extraordinary circumstances, but the vast majority of the time they issue it before the 12-month date. So that is how we get to the 18-month typical timeframe, 6 months to institution and then 12 months to final written decision. If the case is not instituted, then the green part of the slide you're seeing, the 12 months of the trial, is not there, right? It's just not instituted, and we have some discussion later on about what are some options that both the petitioner and the patent owner have if they're unhappy with the decisions made at the various decision points, the institution decision and the final written decision. But that is the basics of how a trial proceeds and the timeframes that are associated with it.
Right. Now, if I'm suing a district court, right, does the other side have a certain time period from when to file the IPR or PGR?
Hey, Dina, if a party is sued in district court for patent infringement, that party is going to have 1 year from the service of the complaint alleging infringement of the patent to file an IPR or a PGR. It's the infamous 1 year bar, and that 1 year time frame runs from service of the complaint, even if the complaint is later dismissed, whether that dismissal is voluntarily or it's dismissed for having defects. One thing I will note is that there's a recent PTAB decision that explains that even if setting aside issues with the complaint, as long as it served the 1 year bar starts, but the service of the complaint must be effective service, meaning it must comply with the federal rules of civil procedure. Even though the party would have that 1 year from service of the complaint to file the petition, it's generally a good idea to move more quickly than that. For example, getting your post-grant review trial petition filed earlier in that 1 year period rather than later can, for example, maximize the chances of a stay of the co-pending litigation, because it's not going to let the litigation advance that much further. Can maximize the chances of the IPR or PGR becoming final before the district court might become final. There's sort of this race to finality when you have these parallel proceedings. And beyond that, filing earlier in the window rather than later is going to minimize certain discretionary denial issues that can occur. For instance, if you file a petition late in the window and you're in one of these fast dockets, it could be that the district court case has progressed so far, and it's going to actually end up at trial before or maybe even shortly after the PTAB would issue a final written decision on your petition. And they can view that as sort of contrary to one of the purposes of the PTAB, which is supposed to be an alternative option for resolving disputes. At that point, it's sort of like we're doing the same work, and that's a reason why they can deny your petition, and that's under Fintiv is the name of that doctrine.
Yeah, so I guess from what I'm gathering here, the stay is not automatic also.
No, you'd have to go to the district court and ask for that. And I think to really maximize your chances, you would want the district court to be early in the process, and ideally you have the institution decision and it's positive. So you can go to the district court and say, hey, this has been instituted. It's going to really simplify the issues in this case if the patent or even just some of its claims are knocked out. And, look at where we are. We're not very far, maybe in discovery, and maybe there's no trial date set. And that's, I think, going to greatly increase your chances of getting a stay in the district court.
Now, Ilya, how long does it take to prepare one of those petitions for post-grant proceedings?
So preparation time, it varies, depends on how much detail and how much time you have. I mean, I've prepared an IPR or PG. Well, it was an IPR petition, but I think it would cross over to a PGR in 3 weeks, and that was a very quick turnaround from doing all of the prior art searching and putting grounds together. That was abnormal in my practice. Generally, I think 2 to 3 months is pretty standard. Obviously, sometimes it can take more if you have particularly complex claims and the prior art isn't that great. One of the benefits of PGRs is that you might have some grounds that prior art grounds that maybe aren't too strong, but then maybe you can raise a 112 or a 101 ground in the petition, and maybe that ground would be stronger. So when you're preparing, I think that one of the benefits of a PGR is just that broad array of grounds that you can raise, and that's very helpful. Going back to kind of the timeline with preparation, you do to get those stays in district court, you do want to move quickly, because you want to, from what I've seen, you want to get an institution decision. I know in Delaware, if you try to move for a pre-institution stay based on a post-grant proceeding, it's fairly rare that they're going to grant that. Usually you'll get a response saying, let me see the institution decision, and if institution was granted, and then I'll grant your stay. So you want to obviously then, kind of working back from that, get your petition prepared as soon as possible, get it filed as soon as possible, because then you'll get an institution decision early, and it's likely that in the related litigation, you won't have gone through claim construction yet. You won't have gone through kind of some of those benchmarks of the related litigation that will make your chances of getting a stay less, and also minimize your chances of getting a discretionary denial from the PTAB because the litigation is so advanced.
So from what I'm hearing, it's about 3 months if you're on steroids to put together a petition, but usually it takes about 2 to 3 months. What goes into filing a petition? Roshan?
Thanks. That's right. So LAR's estimates the 3 weeks and 2 to 3 months is, as you're about to hear, is a very aggressive timeline, and kind of working in the ideal scenario. So what do you need in a petition? Well, this is for the attorneys listening to this, a petition is much like a motion for summary judgment rather than a complaint. Meaning you have to set forth the evidence with particularity and explain the reasoning as to why each element of the challenge claimed is taught or rendered obvious by the prior art. Or in the case of a post-grant review process, where you get to make challenges to a patent claim without prior art, but based on, for example, that the patent claim is indefinite or otherwise patent ineligible, you have to set it forth in that level of detail. So what you need to do is explain in detail each reason you think the claim is invalid. You need to give and set forth any particular understanding of the claim language, referred to as claim construction, in that document. You need to identify all the evidence that's relevant. And most petitions include an expert declaration. So you need to secure the services of a technical expert and get them to declare, and they can be deposed during the trial. So the declaration needs to be defensible as well. And then there are some ministerial requirements separate from the patentability aspects of the challenge. Who are the real parties in interest? You need to have copies of the relevant evidence stamped as exhibits and pay certain fees. So as the slide lays out, that's the case. But I think the takeaway for those who have been involved in district court litigation before is that an IPR petition is much more like a motion for summary judgment in terms of its detail and particularity, and then the necessity of staying within a word count, than it is, for example, a complaint or an answer, sort of a pleading document, which is what most people think it may be initially. But after doing some investigation, they realize that it is much more involved.
Right, aside from the fees, right?
Aside from the fees, that's right.
So if I'm a petitioner, can I file multiple petitions? And when would I consider filing multiple petitions? Jeremy?
Sure. A petitioner can file multiple petitions. I think multiple petition situations face headwinds. They can be discretionarily denied, and there are frameworks for doing so. I guess there are 2 ways a petitioner can pursue multiple petitions. First of all, a petitioner can file multiple consecutive petitions. So one and then wait a little while and then another, and these are referred to even by the PTAB as serial petitions, or a petitioner can file multiple simultaneous or nearly simultaneous petitions that then run in parallel, and then those are referred to as parallel petitions. So starting with serial petitions, the board applies factors from a board decision known as general plastic. And these factors basically consider whether there's any explanation, and we're talking about serial petitions, for the delay between the initial petition and the serial petition, whether the petitioner, before filing the serial petition, had the benefit of patent owner's preliminary response on the initial one or the board's institution decision. And based on factors like that, they can discretionarily deny the serial petition. And this actually dovetails nicely with what Roshan was saying, in that this is a motion for summary judgment. You have to get everything in there. In a situation where I don't think I would try to file a serial petition, absent extraordinary circumstances, let's say my first petition is denied, I would not come back with a serial petition trying to fix the defects that were identified in the board's institution decision, because I mean, that's going to be very hard to get instituted, right? They're going to say, this is your second bite at the apple. The other type of multiple petitions is the parallel petitions. And these, even in the trial practice guide, are described as disfavored because they're burdensome and inefficient. And so if there's going to be parallel petitions, the petitioner really needs to take active steps in the petitions to explain why we need two petitions to begin with. Why can't it all just be in one? And it needs to be specific, right? So one example would be patent owner asserted, I don't know, 150 claims, and I can't get them all of this patent, and I can't get them all in one petition. So maybe you need two petitions there. Another good example, and this one's in the trial practice guide, is you may need to use multiple sets of prior art references to challenge, let's say, a given claim because there's a dispute about the priority date, right? We don't think it's entitled to its priority, and this first set of references is really solid prior art. But then maybe the other side in district court is saying, no, we do get priority. Those references aren't prior art, and now you need to come forward with another set of prior art references in case the patent is entitled to its priority date. So as you can see, these are very specific situations that again, the petitions need to articulate. Just in general, absent something like that, I don't think I would file parallel petitions. It'd be better to have your best arguments and put them forward in a single petition. And that's just my take. And I'd be curious what the other panelists have to say about that.
Yeah, I would agree with that. I've been on the patent owner side for when there were multiple petitions filed against a single patent. And it kind of depends. I mean, all of the reasons that you just articulated, like a large number of claims asserted, the priority date issue. Yeah, I've definitely seen that there have been multiple petitions in those circumstances. And generally, I think like those can be successful. Because there is kind of a definite reason as to why you need to file multiple petitions. From my perspective, in the example I was working on where there were multiple petitions, we raised all sorts of arguments why those multiple petitions were not necessary. We hadn't asserted a large number of claims. The first petition could have included, in our view, all of the grounds that were across the two separate petitions if they really wanted to. What the strategy we used was that, look, the only reason you filed two petitions here was just to shoehorn additional challenges before the PTAB and try to get these additional challenges in. And you know, as a petitioner, as you mentioned, Jeremy, you want to put in your best grounds. You have to be selective if you're going to put forth your single petition, which is kind of what the PTAB wants you to do. So yeah, I mean, I think in my experience, yeah, unless it's one of those situations where two petitions really seem necessary, that it's not favorable to bring multiple petitions.
Okay, so I have a follow-up question on the serial petitions and general plastic factors. Do they apply to the same petitioner or to different petitioners? Because I can envision a scenario where you have a first petitioner who files a petition, the patent owner files a preliminary response, and then you have a second petition filed by a different petitioner who gets the benefit of the patent owner's preliminary response. Is this something that PTAB allows, or is this practice discouraged? And I'll open it up to anyone.
So I can actually take that one. In that circumstance, general plastic may apply. What the board is going to do, should patent owner raise the issue, and they should, is consider the relationship between those two petitioners. And it's going to be a very fact-based analysis, but in general, the closer the relationship is between those two petitioners, the more likely the subsequent petitioner is going to be discretionarily denied under general plastic. So it does not have to be the same petitioner for the serial petitions in order for discretionary denial to apply. It's going to basically amount to, is the second petitioner just litigating on behalf of the first petitioner, right? It's sort of like, are they acting like a proxy, or are they otherwise in privity with the first petitioner, such that they should be essentially bound by what happened, or they should even be bound together for purposes of the two petitions for general plastic.
Yeah, I would add some
I think
intuition. Sorry, yeah, I would add some intuition here. So one of the lodestones that the Patent Office is using to try to make these decisions to discretionarily deny multiple petitions from the same or similarly situated petitioners is they're trying to balance kind of two things. One, they want to protect patent owners from just, facing a death by 1,000 paper cuts of petition after petition and petition filed by, dozens of companies to then essentially bankrupt the patent owner, right? So they want to protect the patent owner from multiple petitions. On the other hand, the Patent Office recognizes that the laws and what Congress passed allows a petitioner, especially one that's sued, to file their own challenge, right? To have a right to their own defense. And so if you think about what it means to balance those from a policy consideration, you're going to get close to how the Patent Office has in the end ameliorated these competing concerns, right? Which is, look, if you're a patent owner and you sued 3 different defendants that are just basically 3 different companies, then you should expect that you're going to face multiple challenges from each of them, right? And that the board's going to be they're not going to care as much that you're facing the third challenge because the board is going to typically err on the side of allowing a petitioner sort of the right that they have under Congress's laws to challenge a patent using this process, especially if they're sued. Some of that starts breaking down, for example, in a supplier-customer relationship, right? So if you sue a customer and a supplier gets involved, a customer files their IPR, and then a supplier files a sort of a follow-on IPR or PGR, then there's a commercial relationship, right? The supplier wasn't sued, the customer was sued, but the board is going to be pretty savvy to the understanding that there's an economic relationship between these petitioners, and that they might be sort of coordinating their attempts to create an unfair situation for the patent owner. So that doesn't mean that suppliers and customers can't file their own petition, because again, they are separate entities, but those are some of the issues the board is going to look at to try to look into whether they should deny, trying to balance these types of equities. Elia?
Yeah. So Roshan, your point is actually something I was going to raise relatedly. So the Valve case, the presidential PTAB case, kind of talks about one of those factors as to when serial petitions and the relationship between serial petitioners is going to be examined. And I think in that case, the issue was that the initial petitioner and the later petitioner in district court, they were accused of infringing, I think it was the same products. So that was one of those instances where there was kind of a relationship between those petitioners that was not in favor of the serial petition.
All right, so let's assume the petition is filed and the patent owner responds in the preliminary response, or we also call it a popper. What goes into the preliminary response? Eliar?
Yep. Unmute myself again. Sorry, having issues getting to the unmute button. So your preliminary response, it's your first chance as a patent owner to respond to the petition. You have 3 months after the notice of filing date is accorded issuance. So that can be a little over 3 months from when the petition is filed generally. And at that point, I think Jeremy already mentioned it earlier in the presentation, but you can raise both procedural and substantive issues, and basically point out, what did the petitioner get wrong in the PGR petition? So from a procedural aspect, it can be, the petition just doesn't comply with the rules. That can come up. You can raise that in many different ways. But one way of raising that is if there are claim terms that likely implicate means plus function, and the petitioner should have presented some sort of construction of that in the petition, and they did not, then you could raise that and say, the petitioner hasn't met their requirement of construing the claims as to in the petition, and explaining how the claim should be interpreted. And then any other other procedural arguments as well. That's your time to raise those and try to get the board to latch onto them and deny institution. The other aspect that you can raise in your preliminary response is on the substance. So if there are key substantive defects that you think you can point out to get the board to deny institution, that's your opportunity to raise it. Sometimes, for different strategic reasons, you want to be selective in what you're going to raise. One issue that comes up is, do you want to submit an expert declaration with your preliminary response? A lot of times as a patent owner, you don't do that, but it's something that you could do if you wanted to. Sometimes it can just turn into a pre-institution argument of the experts, because likely the petition is going to be accompanied with an expert declaration too. So if there is really an issue that has to be resolved based on expert testimony, the board may just institute trial, and then you have to argue that after depositions and with the post-institution briefing. But it's an option, something that you can include with your preliminary response as a patent owner if you'd like. So I think those are generally the key points that you think about when you're raising a preliminary response and filing it.
Okay. And just to pile up on this, suppose the trial is instituted and now the patent owner needs to file a patent owner preliminary response. Would that response have more substantive issues, or can the patent owner raise procedural issues again, essentially?
In the patent owner response, like post institution, yeah. So you could also raise some of the same arguments in the patent owner response as well. The preliminary response isn't actually part of the trial record after institution. So if you have arguments that you want included that you made in your preliminary response, and you want the board to consider those arguments in a final written decision, it is the best practice to kind of make those arguments again, because otherwise they might just be ignored by the board. So if there are procedural deficiencies that you think the board did not properly consider in the institution decision, that could end up making the entire case go away, that's definitely something that you would want to raise again in the patent owner response. And so yeah, I think that would definitely be something you want to look at.
Okay. Now,
I'll just add,
go ahead, Roshan.
sorry, yeah, I'll just add one caveat to what Eliar said, which is that if what you argued for in the preliminary response, sorry, there might be a muting issue, Eliar. I think he's echoing. There we go. Thank you, Eliar. So if in the preliminary response, you were asking for the board to use their discretion to deny institution, those types of arguments won't really make sense in the context of a patent owner response. Because at that point, the board has already decided to institute, and now they're under a statutory requirement to issue a final written decision. So from a basically, if there are procedural issues with the petition that doom the petition as a matter of law, as opposed to as a matter of discretion, then keep those in the patent owner response. But if there's a discretionary issue that you want them to look at, for example, that they have already filed a challenge before, or they're using similar arguments as another challenge that has been before, and you're asking for the board to exercise its discretion not to institute, including those in the patent owner response, will likely be ineffective. In fact, will be ineffective, should be, because they can't go back and sort of deny institution after they've instituted by statute. They can dismiss the terminated petition for other substantive reasons, but not discretionary reasons.
Now, at
Yeah,
which point you're...
Sorry, I was just going to add, that's a good point. I think what the intent of what you would include, it would be those type of procedural issues that relate like after institution. Yeah, as Origin said, it doesn't make sense to ask for denial of institution based on those discretionary factors for institution, because then, you know, the ship has sailed at that point. So there's nothing they can do.
So now what about discovery? At which point does the discovery take place? Is this before institution or after institution? Let's have Roshan take that one.
Thanks. So typically, discovery is taken after institution, and it is very limited to the issues before the patent office, namely and mostly whether the patent is invalid or not. So typical types of discovery, and the most common is a deposition of the expert. You can also ask certain interrogatories or request production. There are some other issues like real party and interest, which where you can ask for discovery of documents, but it has to be curtailed to what is before the patent office, which is, you know, who the real party and interest is, or privy, etc. Those are the main issues that relate to discovery that's post-institution. In some circumstances, pre-institution discovery may be warranted, but it's not required. So you have to ask permission from the board to even get into pre-institution discovery. Well, what kind of pre-institution discovery can you get? Well, you don't get, interestingly enough, things that relate to patentability, right? Those are all reserved for post-institution. But what you can get are things that may relate to the discretionary denial that we talked about. And again, real party and interest and the relationship between the petitioner and some other party may be relevant. So to give you an example, earlier we talked about the 12-month time bar, that if a defendant is sued in district court, they have 12 months to file their petition. Well, what if it was a subsidiary of the defendant, right? But that wasn't clear from the record. Well, if you're a patent owner, you should seek discovery of that prior to institution and ask the board to do so if you have some reason to believe that the petitioner is somehow related to another corporate entity that was sued 12 months earlier, or more than 12 months earlier. So those are the types of issues that are granted discovery at times pre-institution that you can see. But most of the discovery is related to patentability issues, and those things happen typically by right post-institution.
And those are confined essentially to a deposition of the expert.
Yes, for the most part, they're deposition of the expert. But again, if there are issues related to the relationship between the petitioner and some other party that may be relevant to the proceeding, then they can get discovery on those issues as well.
All right, so say the patent owner files their response. What happens next? Jeremy?
Yeah, so after patent owner files its response, then the next major brief is going to be petitioner's reply. And as part of preparing that reply, as Roshan touched upon, petitioner is going to have the opportunity to cross-examine any declarants that were relied on in the patent owner's response. So typically, the expert declaration submitted with the patent owner response. The reply can notably include new evidence. It can't deviate from the petition. It can't introduce new theories. It can't change the prima facie case of patentability, but it can rely on new evidence, and it can rebut the arguments and evidence that came along with the patent owner response. And after petitioner's reply, patent owner is going to get a SIR reply. I think the biggest limitation of patent owner's SIR reply is it's not allowed without permission. I mean, you can ask for permission for a lot of things at the PTAB, but these are just the base rules. Without permission, SIR reply cannot include any new evidence except for the transcripts of any cross-examination of any reply declarants. So again, any declarants in the reply are going to, patent owner is going to get a chance to depose them and can cite that cross-examination testimony in the SIR reply, but no other new evidence. After that, the briefing is effectively complete, absent, motions to exclude and a few other sort of tertiary things to the primary case. Then an oral hearing is going to be held, and after that will come the final written decision.
So at which point can the patent owner file a motion to amend, or at which point does the motion practice take place? Ilya?
Sure. So the motion to amend can be filed along with the patent owner response. Oftentimes you can file your motion to amend and kind of submit a contingent patent owner response or contingent motion to amend. Basically, kind of having those contingencies built in for whether the motion to amend is going to be granted or not. But throughout the proceeding, there are various opportunities to file motions. It is more limited, much more limited than in district court practice, and oftentimes you need to request authorization from the board to get authorization to file a motion. We have a few of them listed on this slide deck. Oftentimes it's just to get some sort of relief. You would prepare an email to the board indicating your position and also the opposing party's position after conferring with them. And then, you kind of generally, you'll have some sort of decision. There might be some kind of preliminary briefing that may go on. So, for instance, for additional discovery, you might explain, in that email why additional discovery is necessary. The board might say, kind of, let's submit a couple of short briefs on this issue as yourself and then opposing party, explaining why that discovery is necessary, and then you'll kind of get into the whole process of actually submitting the motion itself. So there is a motion practice. It is for a lot of these different things we've indicated, but it's not as extensive as what happens at district court.
Right. So we're almost out of time, but I also wanted to touch briefly on the oral hearing, oral argument rather. What happens when you have an oral argument in front of PTAB? Is it similar to having one in a district court?
Yeah, it's very similar, in fact. So in district court, you are typically in front of one judge who is asking you questions. And but in the Patent Trial and Appeal Board, you have actually a panel of 3 judges that you're in front of. So in that sense, it's a little bit more like what happens in an appeals court process. And just like the appeals court, and unlike in some district courts, the oral argument has to be confined to arguments and evidence presented as part of the papers that were filed. Whereas in district court, sometimes you can take some live testimony. But there is actually a provision in the rules that allow for the judges to present and examine a live witness. Rarely if ever used. It has been used before, but it's very, very rare. And the format is typically that the petitioner goes first. They usually have a slideshow in which they start presenting their arguments, and then the judges can ask questions at any point and it's time limited, and each side gets their time. The other side cannot interrupt someone, and there are very few objections. So that's very different than district court trial proceedings. Although very similar to district court oral argument on motion proceedings, for example, on a motion for summary judgment. And each side will typically get a rebuttal time period as well. So unlike, for example, Federal Circuit appellate practice, where only the appellant gets to have a rebuttal time, both sides typically get a rebuttal time. And again, the judges can ask questions at any moment during that process.
Right. Now, how quickly after the oral hearing does the board issue a final written decision? Jeremy?
So the final, that's the oral hearing date. I don't know that there's a specific timeline between the oral hearing and the final written decision. The overall timeline is from institution, it's going to be 12 months to the final written decision, absent good cause, and then that timeline can be extended by 6 months. I mean, maybe another panelist knows if there's a standard amount of time. I want to say it's usually around a couple months.
Yeah, I see Ilya nodding. So yeah, I think you're right, Jeremy. A couple of months. Sometimes it can be a little bit more, sometimes less, but that's usually the standard amount. So if what goes into this final written decision? Is it similar to PTAB's order to institute trial, or does PTAB differ in what goes into the final written decision?
I would say they're very similar. Both are typically going to include a discussion of the patent, the prior art, as well as the parties' respective arguments on various issues. The one difference, or one potential difference, I guess it is a difference. The final written decision is gonna go on and not just decide that there's at least one claim, that there's a reasonable likelihood that the petitioner has shown to be unpatentable, which is what you're going to see in the institution decision. And I guess technically they only need to decide one claim for purposes of institution under that low reasonable likelihood standard. The final written decision is going to consider the patentability of each of the challenge claims based on a preponderance of the evidence, and actually conclude with, the board's ultimate findings on anticipation or obviousness and what have you.
All right, awesome. And I guess one last question, and then we'll conclude the webinar. If the party is not happy with the final written decision, what are the remedies? Ilya?
Sure. So there are a few different remedies. There's the request for rehearing that the party may submit. So they have 30 days from the final written decision to file that request. The same panel that issued the final written decision is going to rule on that. So basically what you would argue is that the board or that panel overlooked or misapprehended a matter in the record when they were issuing the final written decision. And you also have to identify specifically what they got wrong and where that was addressed in the record. The PTAB has said that these requests for rehearing are not intended simply to be a vehicle to disagree with the outcome of the final written decision or provide new arguments. You have to actually show that the board got something wrong based on the record and should have considered something and they didn't. Generally, success is limited. I haven't seen a whole lot of them being successful, but there have been instances where they have been granted. That's one possibility of something you could raise. Another thing you can do is file a director review. This would be in lieu of a request for rehearing. You can't do both a request for rehearing and a director review, but you can seek director review on a final written decision. And that's also within that 30-day period from when the final written decision issues. There, you have to show that there's been an abuse of discretion. The board got something wrong that is an important issue of law or policy. There was an erroneous finding of material fact or an erroneous conclusion of law. And along with those director review requests, you also basically submit a little email to the director, just explaining your, all of those grounds in addition to the director review request, and that will kind of perfect your director review submission. And again, and likelihood of those been granted, it's pretty low. I had pulled the stats a while back, and I can't remember exactly what it was, but it was something like less than 10% easily, likely even lower. But if there is if there's a genuine issue that has importance, and and the board really got something wrong, then it definitely makes sense to raise it, and you could get a positive decision. The third way is just an appeal to the federal circuit. So you have 63 days from a final written decision to submit a notice of appeal. You need Article 3 standing to appeal to the federal circuit. And there, you would raise your legal issues such as claim construction and obviousness. That's reviewed de novo by the federal circuit, so without deference to the PTAB's conclusion. But the factual findings underlying the legal determinations made by the PTAB are in the deferential substantial evidence standard. So there's just other considerations at play when you're making those arguments to the federal circuit. So those are kind of the three main avenues for if you're not satisfied with the board's final written decision.
Okay. Well, that concludes our webinar. We had a wonderful panel with Jeremy, Roshan, and Ilya, and a big thank you to them and also to our listeners. And we'll see you in 2 weeks when we will be discussing what goes into the post-grant review trial petition. Thank you, everyone.